There is a bill in the California state legislature named AB 1757. This bill specifically covers website accessibility. If AB 1757 were to pass, it would have significant consequences for the digital world. And many of you watching this video, including website owners, web developers, web designers, digital asset creators, and more, would be affected. Now, I covered AB 1757 last year in a series of videos, but since those videos, there have been amendments and changes in the language of this bill. So I'm going to cover and go over some of those changes now. And the last amendment was on August 15th, 2023. But the reason I'm covering AB 1757 now is because there's been activity surrounding this bill in recent weeks. And one source of activity was from the Los Angeles Daily News. There's an article: proposed California digital accessibility law would halt startups in the Golden State. And I was quoted in this article. I will link to it in the YouTube description. But after I was quoted in this article and it was published, I received a media request from another major news outlet on AB 1757. So, with that in mind, there has to be some activity surrounding this bill. So, with the activity going on, I thought it would be a good time to cover some of the most important language of AB 1757. So now we're going back to the bill language itself. And let's start by looking at the damages. So the first line reads: existing law imposes liability upon a person who denies, aids, or incites denial of, or makes any discrimination or distinction contrary to rights afforded for actual damages suffered, exemplary damages, a civil penalty, and attorney's fees. Note all of those different ways that plaintiffs can collect money from defendants. Why would you have that many damages available for something that is already very difficult to work around? We know that the Department of Justice, the DOJ, the regulatory and enforcement agency behind Title II and Title III of the ADA, has struggled to produce regulation on digital accessibility. And in fact, to date, they still have not. So it's been over a decade, and the DOJ has yet to issue regulation. And I think the primary reason why is it is so difficult to craft a law around digital accessibility. So given that, and given how easy it is to have an accessibility issue on your website, all of these different ways for plaintiffs to collect money are wholly unnecessary and curious. Why would you have so many ways to collect money and so many ways to penalize defendants over website accessibility? And at this point, I'd like to note that there are accessibility issues on the very California.gov website I am on that I am reading this bill. So given that ca.gov still is not fully accessible, how can you impose so many damages, so many penalties against potential defendants under this bill? All right, so we've covered that, and now let's move on into the standard. And the standard on the surface level is a very broad standard, and they talk about and let me read from my notes. The standard is if a website fails to provide equally effective communication or full and equal enjoyment of the entity's goods, services, etc. So we're back to this very broad general language that doesn't tell us how exactly do we become compliant with this bill. So at the very surface level, initially, we don't have anything that's resolving the clarity aspect of website accessibility. How can I tell somebody you are compliant with this law for sure now because of you've done A, B, and C? No, we don't have that. We have this very general standard. So continuing on, we get to what would the plaintiff would need to do in order to be entitled to statutory damages for the website's inaccessibility. And so it says the plaintiff to prove either that the plaintiff personally encountered a specific barrier that caused the plaintiff to experience a difference, or that plaintiff was deterred from accessing all or part of the website because of the website's failure to provide equally effective communication or to facilitate full and equal enjoyment. Okay, those are two subjective means for the plaintiff, because when we talk about the plaintiff personally encountering a barrier, how do we disprove that? How do we disprove in the alternative that the plaintiff was deterred from accessing all or part of the website because of the website's failure to provide equally effective communication? That is a nightmare for the defense, because we're telling somebody what they have experienced or when they were deterred from something. That's going to be really, really difficult to do. So that's another way I have a problem with this bill. We need to provide an objective means of knowing, okay, we are compliant. Our website is accessible to the point where it is in compliance with the law. And then, so when we continue on, the defense really becomes the website. It says the bill would specify, or the bill would provide, that an entity's website is presumed to provide equally effective communication and to facilitate full and equal enjoyment for the purpose of determining whether an award of statutory damage is warranted, as specified. The internet website has a certain certification by a professional reviewer as defined, that, among other things, the website is designed and intended to conform to the internet related website accessibility standard. And that standard, as defined lower, is WCAG 2.1 AA. So here we are back full circle to WCAG 2.1 AA, which was really the focus in a previous version of this bill that I covered. And now here we are back to it. It comes by way of a certification by a professional reviewer, but this is really how you defend against the subjectivity that the plaintiff has in determining and filing a complaint that says they were deterred or that they experienced a barrier. So what do we have here? Again, WCAG 2.1 AA. And of course, as we know, these are very extensive accessibility standards that are comprised of many different requirements for conformance. And within these different requirements, there are layers to accessibility. And so we get to the certification aspect, and continuing down my notes. So an entity has to have this professional reviewer. And then now we need to look at all of the subparts of that certification and of that review. So I'm continuing down with the bill. And then here we have this section C, subsection 1, and we have this presumption of equally effective communication and full and equal enjoyment if we have all of these criteria being met. So the website is certified by a professional reviewer. The website is designed and intended to conform to WCAG. And when we say designed and intended to conform, this is really a throwaway here, because what does designed and intended to mean anyway? I can design a website and intend to conform all I want, but do I conform or do I not? Then we have the internet website has been tested in both an automated manner and a manual manner by qualified users and has been determined to conform to the internet related standard. Again, we are back to WCAG conformance. And then we have another section that really gets to third-party integrations. I'm not going to read through that, but just know that if you're using an integration, the integration would need to be accessible as well. And then we get to the certification. So it says the certification must meet the following requirements: is made within 12 months or after revisions to the internet website that impact accessibility, whichever is more recent, and is based on a review that includes testing by qualified users. So here we already have a very difficult scenario, because if you revise the website or if the certification is aged past 12 months, then we could have a problem. Then it continues, the certification is posted by available by a clearly marked link on the homepage. So here we're going to have a race to certification. All of these different entities will be offering certification. Is their certification any good? Is it rubber stamped? It likely is, because it's going to be a pay for certification type of field. And I'm very interested to see who would be the entities that are certifying. And here comes the last part. It says the certification includes a statement from the professional reviewer explaining how that person qualifies to be a professional reviewer. If the professional reviewer is not certified, is not a certified professional in website accessibility or web accessibility, a CPWA, with a certificate issued by the IAAP, International Association of Accessibility Professionals, the professional reviewer shall provide another type of source that they are trained. Well, so one problem here is a CPWA doesn't necessarily mean you are even qualified to evaluate a website and determine whether it is conformant with the Web Content Accessibility Guidelines. There's nothing wrong per se with having a certification issued by the IAAP, but that's not going to mean that you're necessarily conformant. Um, Moreover, there was another point I wanted to get to, but this is problematic because the other point I was going to get to is you're going to have this race to certification. There aren't even enough people, accessibility professionals, to issue all of the certification requests that would come through. So this is really a slippery means of getting back to WCAG conformance. Although it doesn't word it outwardly facing like in the previous version I covered, here we have another problem with certification. So this is really, really problematic. And then we have a section, it's the resource service provider section. And let's see if I can find it really fast on the screen. Okay, here it is. It says in Section 3, Section 55.566, it is unlawful for a resource service provider to do any of the following. And then it says intentionally, negligently, recklessly, or knowingly construct, license, distribute, or maintain for online use a website that fails to provide equally effective communication or full and equal enjoyment. And then, so just on that, what this gets at is if you're a web developer, if you're a web designer, if you are in charge with maintaining a website, if you are an app or a plugin maker, if you are a platform, then you could potentially be liable under this bill. And this bill would also authorize a civil action by a person or an entity that pays or contracts with a resource service provider to maintain the accessible website that is accessible. So this would also give an outlet for additional litigation from the person that contracted with the resource service provider. So it could be a web developer, a web designer, etc. So here we have even potentially more litigation. And then we have web developers and web designers that may not want to participate because of the immense potential liability that they would face. And here we get back to, okay, WCAG conformance. What if you have two things wrong? This bill doesn't get into the nuances. So it's very difficult to create a digital accessibility law. And it's a thought exercise worth going through if you were to start to look through this bill or potentially create a law, like in theory yourself. You work through it, and it's very difficult to create the law. And this is the DOJ's domain. They are very knowledgeable on website accessibility. I would leave this to the DOJ, and we know that they are actively working on Title III regulation or Title II regulation, with Title III likely coming shortly thereafter. I would wait for the DOJ because you need to understand website accessibility before you can craft a law around website accessibility. So I would say, let's not even deal with AB 1757. You're not ready for it. You're not ready. You don't understand website accessibility to create this law. Um, and it's difficult. It's not really a knock on anybody. It's just that you need to be intimately familiar with the Web Content Accessibility Guidelines. As I pointed out, you need to be aware of the resources available. If you are going to be stipulating certification, everybody's going to race towards certification. You will have all sorts of people offering certification. They will run to get the IAAP certification, and then you'll have people issuing certification, and there will be pressure because there'll be payment. People will say, make my website or tell me my website is WCAG conformant. And even with certification, right? Even if you have a solid conformance statement, it's still not going to cover the entire website. So knowing that would be helpful. We need to get back to at what point is a website accessible, what level of issues are permissible, and then also what about the website owners who can't afford services? This is going to stifle commerce. This is going to stifle small businesses. And so you have to understand how many resources, how much of resources and just are needed to work on and eventually get to WCAG conformance. And it is a significant amount of resources. And as CA.gov can tell you, the creators behind CA.gov can tell you a lot of work went into the accessibility of California's website. They need to look at the cost of that, and then they need to look at the cost of finally making it conformant because it's still not WCAG conformant. Um, so a few more thoughts. Wholesale incorporation of the Web Content Accessibility Guidelines does not work. It can work for other laws, but not given the ultra litigious atmosphere in the United States. As I mentioned, certification creates a race to certification, and then I've talked about all of the fallout from that. One good thing about this bill and the wording of this bill is it already dismisses overlay widgets. If we needed anything further to tell you that overlay widgets do not make a website accessible, this bill is evidence of that because in nowhere does it say install a widget and your website will be considered compliant. Um, Service provider liability just creates even more litigation. And then we will have so much litigation going back and forth. It will be ridiculous. And there's already an avenue for potential liability of a service provider, and that is through promises bargained for in a contract. And then some ideas I have, just some suggestions. Provide a notice of 1 year for different entities to become in compliance, have phased compliance. So you could have a very simple rule, such as no scan errors and then making sure your website is keyboard navigable. I understand that is not the perfect outcome, but it is something that provides a definitive point at which we can say we have reached compliance for this initial phase. And then I would also say work with major website platforms. When we have Shopify, Wix, Squarespace, GoDaddy, WordPress, when they are all upping their accessibility game, the web is going to be so much more accessible because those platforms will be helping people become become accessible. Also, the severe penalties are completely unnecessary, especially when we consider the fact that so many claims being made are disingenuous and they are from testers and not actual people that are intending to avail themselves of a given website. We want to disincentivize law firms from serial litigation. So we need to, again, when we get to the law, we want to create a good law. And one other idea I had before I get to a good law: tax credits for website owners to help them get this done will be immensely helpful. So if you can subsidize or offset the cost, that will be very helpful in ensuring a more accessible digital world. But when we think about the qualities of a good law, one, there is clarity, two, there is fairness, and then three, it's effective. So when we talk about effectiveness, this means we reduce litigation and we promote accessibility. This is only going to inflame accessibility litigation that is already out of control. And that is almost word for word my quote that was in the Los Angeles Daily News. When it comes to fairness, small business owners should not be disproportionately impacted on the surface, and this will also discourage startups. So, and it will discourage resource service providers. So, we're going to see we'll see a major impact if this were to pass. And then again, we get back to clarity. We initially have this very ambiguous surface standard that we've had all along. So they need to improve upon this if they are going to come up with a new law. And there is so much nuance needed in a digital accessibility law, and this bill simply does not have it. It did not have it in the past, and it does not have it now. This is very problematic, and it will only lead to more litigation. And so what I recommend is that this bill just be shut down and we look to the DOJ for guidance. The DOJ is so knowledgeable. They've been working on this for quite some time. We know how important it is, but we need someone who is knowledgeable, who has spent the time, who is aware of the nuance necessary to come up with a law. And then any state law, if you want to have a state law, then you just have it mirror that federal law closely, because the federal law is going to make considerations and really important ones. So, as important as accessibility is, and it is essential, we need to have it. This is not something that you can simply ram through by saying, hey, now everything needs to be accessible. Because, as demonstrated by the very website that this bill is being hosted on, working to full WCAG conformance can be quite an endeavor. And it's just unrealistic to state that everybody needs to be WCAG conformant, or you are going to be sued, and there are going to be all these penalties and damages because because you were non-conformant with a specific success criterion or a group of success criteria. That's not the way this needs to work. There needs to be more nuance in the law, and so for that reason, I recommend waiting until the DOJ issues regulation.